If the problem has nothing to do with your work, why are you paying a bunch of money to, ultimately, attorneys? Now in this video, we're going to provide a basic outline of what a Chapter 558 notice is, but don't worry, we're not going to quote state statute or anything. We just want to provide you with a fundamental understanding of what it is, but most importantly, what you can do to protect yourself. So stick around. It seems that most laws are written with the intention to protect the consumer, particularly from companies and corporations. But in the case of the Chapter 558 notice, it actually affords a lot of opportunity for the contractor to defend himself from expensive and drawn-out lawsuits. Okay, enough setup. Let's get started. What is the Chapter 558 notice? Leaving out the legal mumbo-jumbo talk. The Chapter 558 is a section of Florida law that was designed to reduce lawsuits. It does this by requiring that the contractor has an opportunity to inspect or perhaps make an offer to repair problems associated with their work. And this would happen before a lawsuit could be filed against them for that problem. So basically, a lawsuit cannot be filed against the contractor until the time period of the Chapter 558 notice runs out, or it's determined that a settlement between the two cannot be reached. The problem, and I'm talking to contractors here, every contractor who came in contact with the job gets named on these Chapter 558 notices. And it doesn't seem to matter if the alleged problem was in no way related to the work you did there. So if you're the drywall guy and they're alleging a water damage claim, you would think you're in the clear, right? Nope. There's your name right there on that document that's alleging water damage. Why? We have a few theories, but for now, let's just get to your immediate problem. So you receive a Chapter 558 notice and you send it to your insurance agent. And your insurance agent sends it to your insurance company. So what happens then? Well, the insurance company hires an attorney, and that attorney begins corresponding with the other attorney, the one who put your name on that document, and this chat goes back and forth for what seems like forever. Then sometimes the insurance company decides to make an offer to settle the claim, to make it go away. But whose money did they use to make that offer? Yours. Who pays for the attorney's correspondence going back and forth? You. And whose loss history gets littered with all this activity, these claims being paid, these defense attorneys being paid? Yours. That's your money being spent, and you might not have had anything to do with the problem to begin with. There's even more than that, but let's get on to the good news. I don't want to get you all riled up. In the vast majority of cases, the Chapter 558 notice was filed wrong, meaning the notice didn't adhere to the strict requirements of the statute itself. So the very statute they were using to complete the 558 notice was incorrectly completed. See, within the Chapter 558 statute are the instructions on how to file it, what information is required, and they are very specific. The good news for you is we know those. I know I said I wasn't going to put legal mumbo-jumbo on the screen. Let me just show you one thing. The notice of claim must identify the location of each alleged construction defect sufficiently to enable the responding parties to locate the alleged defect without undue burden. So, did they do that? Did they spell out specifically what defect is being alleged and where it's located so that you could find it? Because if not, then they didn't follow the strict requirements of the very statute they are using to put you on notice. And there's a lot more. There are specific time restrictions for each party, and of course there's the proper way to respond. And the response is very important. So you really need to know this stuff so you can protect yourself, because your opportunities to protect yourself are in there. I'm sure you'll agree that if there is a legitimate problem with a property that can be attributed to your work, then you'll address it. I'm sure you do this all the time. You send somebody over to take a look at it, and you want to make your customer happy. Perhaps you make the repair, and it wasn't even on you to do it. But if the problem has nothing to do with your work, why are you paying a bunch of money to, ultimately, attorneys? And just to clarify, we are claim administrators. We're a third-party administrator or a TPA. So we work for our clients, not for the insurance company, in handling claims. So let us know if you'd like to fight back on these things. I hope you found this information helpful, and thanks for watching.